All right, in this video, we're talking about the Readiness Conference or the Status Conference. And this is the third video in our series in which we're walking you through a criminal case. You'll remember that the first video was on arraignments, which is the first hearing in a criminal case. Our second video was on the discovery process, and you'll remember that's the exchange of information between the parties. And now we've gotten to the Readiness Conference. And before we get into the details of what the Readiness Conference is, it's important to draw the distinction between misdemeanor cases and felony cases. So a misdemeanor case is going to be a lesser criminal offense, one that you can do up to a year in county jail, as opposed to a felony, which is going to be a more serious case in which you can do anywhere from, prison time. You can also, you can be sentenced to county jail on a felony or probation, but it can go all the way up to life in prison. So as you know, felonies are more serious. So as between the misdemeanor and felonies, there are some procedural differences in that in both misdemeanors and felonies, you are going to have the first hearing be an arraignment, and then the second one is going to be the Readiness Conference. But in a misdemeanor, the next step after the Readiness Conference is going to be a trial, as opposed to in a felony, you are going to have the arraignment and a Readiness Conference, but then instead of the trial, you have what's called a probable cause hearing or a preliminary hearing. And then after the preliminary hearing, if the case moves forward, then you have another Readiness Conference, and then you have a trial, right? So that's the major difference, besides the seriousness of the offense and the amount of time you're facing, just procedurally, those are the differences between the misdemeanor and the felony. Again, you have misdemeanor and it goes arraignment, Readiness Conference, trial. In felony, you have arraignment, Readiness Conference, preliminary hearing, Readiness Conference, trial. All right. So with that being said, by the time you get to your Readiness Conference, you should have received, or your attorney should have received, the discovery. And again, the discovery being the police reports, the witness statements, photographs, videos, lab reports, all that information. And so it can vary in terms of how long it's going to take for your attorney to get the discovery, but usually, it can be anywhere from a few days after the arraignment to a couple of weeks, and sometimes it can be months, just depending on what is outstanding. One of the things that happens at the Readiness Conference, and the purpose of it, is to determine if the case is ready to proceed to the next stage. So again, is it ready in a misdemeanor case to proceed to trial, or is it ready in a felony case to proceed to preliminary hearing? And typically the prosecutor is going to make an offer at the Readiness Conference, or if your lawyer and the DA are in contact, they may make an offer prior to the Readiness Conference. Because ultimately the lawyers have to communicate to the judge, hey, what's going to happen with this case? And so if there's being an offer made, or there's already been an offer made, the lawyer, in order to communicate to you whether that's a good offer or not, they won't know until they've had an opportunity to go through the evidence, both, internally as a law office, or the attorney if they're by themselves, or like in our case, in our firm, we go through it internally as a whole team, and then we review the evidence with you. And it's absolutely necessary to review the evidence with you. Number one, because, you have a right to know what the evidence is against you. But the other, more important issue is that the lawyer can't just figure out and strategize the case on their own. We need you to be able to give your insight on, what the defense is, because if you're being accused of having done something, who better than you, or who would know more than you what your side of the story is? Whether that's, you were acting in self-defense, or you just didn't do it, or you may have done this but didn't do that, or whatever your position is. We have to have this interactive process, and it's so important. And it really upsets me when I hear when we get a second or people looking for a second opinion, And they're like, hey, my lawyer hasn't told me anything. I have no idea what's going on in my case. I asked, well, have you guys gone over discovery together? No, I have no idea what the evidence is against me. And that can be insanely frustrating for a client. And I completely understand that. And that's why for us, it is, of vital importance that, once we get the discovery, we get through it internally as soon as possible, and then we're reviewing it with our clients so that we can form our defense strategy together. So again, once the lawyer has done that, then he knows what the evidence is, right? So he knows what the prosecutor's case is, and he knows what the client's defense is. And so then with that information, the offer can be, reasonably considered. And we'll probably do a separate video on offers because that's a whole nother issue in and of itself. But, it's important to understand that really less than 5% of cases go to trial. So of all the hundreds of thousands of cases that are filed, less than 5% of cases go to trial, and then another small percentage of cases are dismissed. So the vast majority of cases end with some sort of plea agreement between the prosecution and the defense. And so that's where we're talking about this whole thing about offers. So when you have a number of offenses, or even if it's just one offense that you're being charged with, typically the DA is going to make an offer, which if you accept that offer, the penalty is going to be far less than if you were to have gone to trial and were to lose at trial. And so that's the incentive for you to take the deal, right? Because if every case, if no reasonable offers were being made in all the cases and everything just had to go to trial, the criminal justice system would literally mess that word up. The criminal justice system would literally grind to a halt because there just wouldn't be enough personnel to be able to handle all the cases, right? So by necessity, there has to be offers in order to resolve cases short of just everything going to trial. Just for an example, let's say there's a case where there's robbery, assault with a deadly weapon, and theft. Right. And a person's alleged to have taken, the personal property of somebody else. In that situation, perhaps the DA will make an offer of, the assault charge and dismiss the theft and the robbery, or they may offer the robbery and dismiss the theft and the assault with a deadly weapon, knowing that, hey, if the DA can prove each of these charges beyond a reasonable doubt, then that could end up in a much higher exposure for that person. Because again, that's another thing, and we talked about that during the arraignment, that your lawyer's going to go over with you the charges that have been filed against you and let you know what your exposure is, so you can know in the worst case scenario, which we said, generally doesn't happen, but in the worst case scenario, how much time would you be facing? And, on these facts, if you have a robbery, assault with a deadly weapon, and a theft, and maybe if a weapon was used, you could be potentially facing decades in prison. So if, again, in the worst case scenario, so the DA might offer you, maybe probation. Maybe they offer you probation and 6 months in jail, right? If they offered you 6 months in jail and probation, then obviously that's going to be a lot better than if you got found guilty at trial and were sentenced to the max. So you might be incentivized to take that if you did what you're alleged to have done. Obviously, if you didn't do these things, or if your conduct was way less than what the charges reflect, then, your lawyer is going to advise you that that's not really a good deal for you to take. And then, some sort of counteroffer could be made, right? But nonetheless, that's just kind of an example of an offer that might be made. And again, I probably want to shoot a separate video on offers because that is a very important topic to discuss. So generally speaking, once a case gets filed, one of three things is ultimately going to happen. Either the case is going to get dismissed, a plea agreement is going to be reached, or the case is going to get set for trial, right? So the status conference, readiness conference, pretrial conference, whatever the word or term is that's used, that's when the judge is going to be made aware of what the parties are going to do in this case. A lot of times there's, actually, let's say that the four possibilities that usually happen, it's either going to be, there's going to be a continuance, there's going to be a plea agreement, there's going to be confirmation of the next step. So whether that's a trial or a preliminary hearing, or the case is going to get dismissed. So those are going to be generally the four options, and we'll kind of talk about those in a bit more detail. So with the continuance, there's a number of reasons why the case is just not ready to proceed to the next step and it's not ready to resolve. Like we were saying, there might be outstanding discovery issues. Maybe, in an assault type case, the DA could be waiting on medical records, which typically are going to take some time because, the patient has to sign a release to allow those to be disclosed, and the DA has to subpoena those records. And so that just takes time. In DUI cases, if you had your blood drawn, then the lab reports can take some time to come back. Usually it's going to be a couple of weeks. So by the time that first readiness conference comes around, the DA may not have gotten those lab reports to the defense yet. In fact, they may not have even received them themselves. In other cases, maybe they're waiting on financial records. There could just still be outstanding evidentiary issues, and that's why the case can't proceed. In some instances, even if the defense does have the discovery, they may not have had an opportunity to fully go through it internally and review it with the client. The defense may still need to do their investigation. You may be, as a defense attorney, still collecting positive information about the client in order to tell the client's story. You could be getting, work records and awards and commendations and letters of support, things to tell the DA who your client really is so that they can understand who it is that they're dealing with. So that would be the continuance. And so oftentimes cases get continued perhaps a couple weeks out. It can be 30 days out. It can be 45 days out, or it can be months out, just kind of depending on the reason for which more time is needed. So sometimes people are wondering why their case is getting continued. Unfortunately, there are lawyers who just drag out a case, but there can be, again, legitimate reasons why more time is needed. You just really need to get on the same page as your attorney and understand the reason why they're asking for more time and making sure that they're not, just needlessly dragging out the case. The next thing would be a plea. Remember, we were talking about, an offer being made if, your lawyer goes over that with you and decides that or advises you that a plea is in your best interest. And if you decide to plead guilty, then at that status conference or the readiness conference is when you would enter your plea of guilty. The other thing would be confirming the next step. So again, whether that's preliminary hearing or a trial, be basically communicating to the judge, hey, we're confirming the trial, meaning we're ready to go to trial. So a trial date is set, or a preliminary hearing date is set, and that would be the next court date. Or a dismissal. Basically, if the defense has worked up the case and presented information to the DA where the DA calls into question whether they can prove their case beyond a reasonable doubt, or the defense presents a legal issue in terms of a bad search or something that they did that might basically destroy the DA's case, or for whatever other reason. Sometimes it can be based on just character information where, the defense sufficiently convinces the DA that it's in the interest of justice and better for society that this case be dismissed as against the person. That's going to be in much more rare situations. But that's where the importance of truly getting to know your client and being able to tell their story is, of utmost, it is of utmost importance, because sometimes that can be persuasive enough in and of itself to convince the DA to dismiss the case. So again, at that readiness conference, you're either going to be asking for more time by way of a continuance, there's going to be a plea, confirmation of the next step, or dismissal in some instances. But that gives you an idea of what the readiness conference is, and what happens is there's a calendar, just like at the arraignment. The judge is going to call each case one by one. The parties are going to let the judge know what's going on. You know, a lot of time you're just going to be waiting around, waiting for your case to get called. But by the time you're in front of the judge, I mean, you'll be in front of the judge for all of 1 or 2 minutes at the most. And then the next dates will be set. Or if the case is getting dismissed, then, you know, the case is closed out. But typically, you know, you're just going to have your next date set, whether that's a new readiness conference or preliminary hearing, trial, motion hearing, whatever's coming next. All right, so that is the Readiness Conference in a nutshell. If you have questions about it, just leave me a comment below. And if you got something out of this video, please show me some love. Hit the like button. Make sure you subscribe to the channel. Turn on the notifications so you never miss a new video when it drops. And as always, I want to thank you so much for watching. And until next time, peace.